Picture this. You're scrolling late at night, and a video stops your thumb cold. Supreme Court, 9-0. Gun laws flipped in 19 states. No permits, no training, no waiting periods. The narrator sounds certain. The graphics look official. And a quiet voice in the back of your head asks the only question that matters. Wait, is any of this actually true? Here's the uncomfortable answer. That ruling doesn't exist, but two real ones do. And what they actually say is more important than the version going viral. So which parts are real? Did the Supreme Court really change where you can carry last week? Yes or no? If you live in California, New York, New Jersey, Maryland, or Hawaii, did something just change for you specifically? Can a marijuana user own a gun now? And the big one, how many of the channels you trust just repeated a number, 19 states, that nobody can actually source? Stick with me, because by the end of this, you'll know exactly what changed, what didn't, and how to spot the fake version in 5 seconds flat. If accuracy is the reason you're here, if you're tired of legal channels that trade your trust for a thumbnail, subscribe. That's the whole channel. And do me a favor, in the comments, tell me which version you saw first. Did your feed serve you the 9-0 19 states video? Drop the channel name or just say, yep, I read them. Misconception number 1. A single 9-0 ruling wiped out a century O. F gun control. It didn't. There was no omnibus ruling. What happened is that two separate decisions came down 1 week apart, and someone blended them into a fictional super case. The first real case is Wolford versus Lopez, decided June 25th. The vote was 6-3, not 9-0. The second is United States versus Hemani, decided June 18th, and that one genuinely was 9-0. So the 9-0 detail isn't invented out of thin air. It was lifted from Hemani and stapled onto a story it has nothing to do with. That's how good misinformation works. It steals a true detail to smuggle in a false claim. And the 19 states number? There's no source for it. The real footprint of Wolford is 5 states that wrote the same kind of law: Hawaii, California, Maryland, New York, and New Jersey. 5, not 19. Real ruling number 1. Wolford versus Lopez, 6-3, June 25th. After the Bruen decision in 2022, a handful of states couldn't ban public carry outright, so they got clever. Hawaii flipped the default rule for private property that's open to the public: stores, gas stations, restaurants, parking lots. Normally, the law assumes you're allowed to walk into a business unless the owner says otherwise. Hawaii reversed that. If you carried, you were presumed banned everywhere, unless the owner affirmatively said, "Guns welcome." Critics nicknamed it the vampire rule. You couldn't come in unless invited. The Supreme Court struck that down. Justice Alito, writing for the majority, said the rule hobbles the right to carry for self-defense as people go about their daily lives. So the default flips back. Carry is allowed in public-facing businesses unless the owner opts out. This is the actual unanimous one. Federal law, Section 922G3, makes it a felony for an unlawful user of a controlled substance to possess a firearm. The government tried to use it to prosecute a man whose only relevant conduct was using marijuana every other day. The court, in an opinion by Justice Gorsuch, said no. You cannot automatically strip someone's Second Amendment right based solely on regular marijuana use. But, and this is the part the hype videos skip, it's narrow. The court did not strike the whole statute. It left the door open. If the government can show that a specific person's drug use actually makes them dangerous, the ban can still apply. And it said nothing about felons, who remain barred. A real win for casual users, but a scalpel, not a sledgehammer. Here's the honest lawyer's answer. It depends on where you live and how you carry. If you live in California, New York, New Jersey, Maryland, or Hawaii, this matters to you. Your state had a version of the vampire rule, and it's now on borrowed time. Expect the default to flip, but expect more no firearms signs to appear at businesses in response. The fight just moves from the State House to the front door. If you live in a shall-issue state with permissive carry, Wolford barely moves your day-to-day. It mostly reinforces that the rules are uniform. A state can't shrink the right by redefining private property into a giant no-carry zone. If you use marijuana, medically or recreationally, and own a gun, Hemani is for you. You can't be auto-prosecuted under 922G3 for that alone. But marijuana is still federally illegal. Lying on the ATF Form 4473 is still a separate crime, and dangerous users can still be charged. Don't mistake a narrow win for a free pass. It depends. Two of the most honest words in law. Anyone giving you a flat yes or no on a Supreme Court ruling is guessing or selling. Why did both of these come out the way they did? One framework, Bruen. In 2022, in New York State Rifle and Pistol Association versus Bruen, the court held that a gun law survives only if it's consistent with the nation's historical tradition of firearm regulation. Not whether judges think it's a good idea, whether history backs it up. In 2023, Rahimi refined it. The government doesn't need a historical twin, an identical old law, just a relevant analog that fixed the principles behind our tradition. Quick accuracy note, because the fake videos butcher this. Rahimi was 8-1, not unanimous, and it actually upheld disarming people under domestic violence restraining orders. It's the opposite of a gun rights blank check. Put those together, and you get the whole totality of how the court is thinking. In Wolford, Hawaii couldn't find a historical tradition of flipping the property default to disarm permit holders. In Hemani, the government couldn't show that marijuana users as a class match the historical dangerous person laws it pointed to. Same engine, two results. Say it clearly, say it once. There was no 9-0 ruling flipping gun laws in 19 states. There were two real rulings. One, Wolford, was 6-3, and it flipped a default in 5 states. The other, Hemani, was 9-0, and it was narrow. Real cases have names. If it has no name, it has no truth behind it. The headline you saw was engineered to feel huge because huge gets clicks. The reality is more modest and more useful. The court is steadily applying one historical test, case by case, and it just resolved 2 of them. Knowing the difference between the real rulings and the viral fiction isn't just trivia. It's the difference between making smart decisions and repeating a stranger's mistake. That's the whole point of this channel. We don't do panic, we do accurate. Now you answer me in the comments. Which fake claim did your feed try to sell you? The 19 states, the strict scrutiny, or the no more permits one? I'll pin the best breakdown. Stay informed, stay accurate. I'll see you in the next one.